And a lot to unpack around that discussion, but especially what has come out of the court. But let's now get some analysis from a legal analyst. We're now joined by Elton Hart from the University of Johannesburg's Law Clinic. Elton, a good afternoon to you. Thank you so much for giving us your time. A pivotal moment, I think, in the Senzo Meyiwa trial. I mean, your thoughts on what we've heard today with the emergence of this second docket?
Yes, but obviously the second docket was always on the table. This to me is just a travesty of justice, because how on earth do you have two dockets running at the same time for one cause of action, for the death of Senzo Meyiwa? Not that I'm saying his death is not important. They're supposed to have one docket, and if you bring additional accused, you just add them, like Advocate Mshololo said, you just join the accused to the current accused that's there. You don't open a separate docket. And the mere fact that the DPP for North and South Gauteng gave instructions that all these people should be prosecuted, they should have been added to one docket, and all 13 of them should have been in the dock. Zandile Khumalo, Longwe Twala, the Phiris and the other Khumalo people that is mentioned there, because obviously there's something to be answered. But obviously this, as I alluded to in early interviews, is that here was shoddy police work. The investigation was not done and conducted as per the standing orders and the national instructions that is issued to SABC members when doing their jobs.
Let's talk a little bit about what happens now. I mean, I just spoke to Senzo Meyiwa's sister, Zama Meyiwa, and one of the frustrations of the family is they've been waiting since 2014, and now another postponement. What does the process now look like?
Obviously, when the state comes now and shove a new docket in front of Advocate Mshololo, she needs to make sure that she checks if her client's constitutional rights is not being violated, and she needs to consult. So what Advocate Mshololo was asking the court is correct, and obviously you cannot just go through a docket for 2-3 days and consult and think, hunky-dory, I have got everything under control. You don't know what's all in that docket. So for the family, for the Meyiwa family, I think this is now their trust in the justice system has just taken another knock, because to wait for 8 years to actually see that the alleged perpetrators who most probably killed your brother, or maybe people that is involved in how your brother passed on, is before court, and there's additional ones that's not even brought before court to actually come and answer, persons of interest. It just saddens the family, because now it will take another maybe 2-3 years for them to actually find out what happened to that child on that fateful day of 26 October 2014.
And then, of course, there's the question of whether or not we will see those that were inside that house on that fateful day actually inside the courtroom facing charges. The likelihood of that, the time frames that are attached to that as well?
Obviously, now you have two DPPs that gave instructions to say there's 5 accused that's currently in the North Gauteng should be prosecuted, but there's also the DPP of the South Gauteng division that said these 7 people, which includes the Khumalos, the Phiris and the Twalas, that must be prosecuted. So you have now 2 DPPs. Now this thing, I think they should refer this thing to the NDPP, Shamila Batoy, to say, should these accused be joined? Should these dockets be joined as one docket, and all of them be accused, stand trial for the murder of Senzo Meyiwa? But again, it comes down to what happened on the day when the crime was committed. The investigative work that was done there, Brigadier Ndlovu's role that he played, or that time he was Colonel Ndlovu, Sergeant Busiwa, how they failed the Meyiwa family to actually get justice for their child. Because I spoke to some of my colleagues in the SABC, and they say the forensic evidence that is being presented here in court, it's scary. It's very scary.
Yeah. Elton, what are the implications now for the 5 men that are facing these charges?
Obviously, as I said on a previous occasion also, now this opens the door for these guys to bring an application in terms of Section 174 to say that, listen, yeah, this evidence was planted to implicate us, and that application has now just gotten much more stronger. The chances of bringing that application has gotten much more stronger because of the emergence of this new docket and the content thereof. So the implications for them is now they need to make sure that they would bring and they would test all the evidence that is currently before court, plus the new evidence that is now being given to them. So Obviously, for the family, they don't want to see this delay, but for the accused persons, I think this is now opening another can of worms, and no reasonable court, with the amount of tampering and things that was shenanigans, if one can put it that way, that has happened already in this trial. I don't think without no court can come to a beyond reasonable doubt to say that these 5 men are actually the real perpetrators that committed this heinous crime.
Yeah. Just quickly before I let you go, Elton, you talked about the Meyiwa family's confidence in the criminal justice system taking another knock. But I wonder if this, in any way helps the public perceptions of the work of the National Prosecuting Authority.
Obviously, if one looks at the work of the NPA, the National Prosecuting Authority, obviously their work heavily relies on what the South African Police Service is doing. So if the South African Police Service is failing in their duties as to what should be done on a crime scene, what evidence should be brought to the NPA so that they can actually successfully prosecute a case, then the NPA's one hand is already behind their back in a handcuff. Obviously, if the prosecutor that's tasked with these dockets, if he makes entries and he doesn't follow up with the investigating officer, if these things has been done and the evidence collected, then they're also at fault for not checking up. But normally SAPS gives the evidence and then the NPA works with that evidence. And if that evidence collection and the preparation of the case is not done properly, then the NPA is already with one hand behind the back with a handcuff on. So that is now how these dynamics work. But obviously, people will now have that we don't trust the justice system. And that's why witnesses sometimes doesn't want to come to court because they feel like they're going to waste their time. Things is not going to, it's going to be protracted litigation, 10 years. Here we're already closing up on 8 years. So next time it will be 10 years for them to come to court. So that might be the problems. And that is also the public perception that's out there, that the wheels of justice is turning at a snail's pace.
Yeah, very interesting. Well, let's leave it there. Elton, thank you so much for giving us your time. Elton Hart there from the University of Johannesburg's Law Clinic.